Number 1.
My lord, the Kotak Municipality Corporation collecting double taxes for the same services towards the different taxes. My lordship, we are challenging clause 9, 10 and 11 of the Kotak Municipal Corporation Parking Space Regulation 2016 and also challenging clause 12 of the Waste Management Bylaws 2017. My lordship, we are paying holding taxes for the service of road, drainage and improvement of the drainage and also solid management by the way of holding taxes.
But why have you waited for 7 years to challenge this? This is a 2016 regulation.
My lordship, the petitioner had no knowledge when the matter was stood. The BMC, one of the organization, has filed before this honorable court and passed one order bearing by WPC number 11885 of 2016. The matter stood.
No. So till now you are not unhappy with this. Suddenly, because BMC regulation has been struck down, you have woken up. You have to explain what were you doing for 6 years, sir?
I had no knowledge, my lords.
Who's I? Not you as a lawyer. There are two petitioners here, sir.
Petitioner has no idea about this fact and imposing.
Petitioner is an association, and
how can it have no idea?
Association.
If something is there for 7 years, you are paying the tax, right? Are you paying taxes for the last 7 years? You are not paying.
Yes, my lords.
Then how can you not be aware?
It is the burden of the petitioner to give the different payments more than 50,000, my lordship.
No, but why? What were you doing for 7 years? This is a regulation of 2016.
Yes, my lord.
What were you doing for last 7 years? Why did you not challenge it?
My lordship, the petitioner had no knowledge, my lordship.
How can it not have knowledge, sir? You're paying tax. How can you say I have no knowledge? Are you paying the tax or you're not paying the tax?
My lordship, paying.
How can you, despite paying the tax, how can you say I have no knowledge?
I came to know that holding tax and also collecting by the UF user charges.
Where have you given an explanation? Let's read your petition. Where is the explanation of the delay in approaching the court? Where is it? And how is it public interest litigation? You are...
Rather, it is against the public because by virtue of
No. How is it a public interest litigation? So you are a private hospital association. It is a relief for yourself, correct? You are seeking relief for yourself.
No, my lordship, for the benefit of all hospitals and also public.
That's right, only for hospitals.
Yes.
It's not for the public.
Yes.
See, it's a relief being sought by the hospitals for the hospitals. Who's petition number 2?
The
Secretary of the
association. You should describe that. You don't.
He has mentioned it in the cost title.
No, it simply says Anand Prasad Rautri, son of so and so. He has not described himself as
that in one, serial number 1, General Secretary Ananda Prasad Rautri.
Okay. Anyway, where is the explanation of the delay? Which paragraph have you explained the delay? So did you draft this petition or somebody drafted it?
My lordship, I am drafting this.
Sorry? Who drafted this petition?
Myself.
So you should know why he has to help you. If you draft, you should be immediately coming down to that paragraph.
Not mentioned the delay.
You didn't think there is any delay. In 2023, you're filing a petition challenging 2016 regulation, correct? First question that should come to your mind is, what were you doing for 7 years? What are you, sir? You're the briefing counsel or?
No, my lords.
No, my lord. We are both are.
You're together. So neither of you thought of this. You didn't expect court will ask you these questions. And why is it a PIL? How is it a PIL, sir?
My lordship, one-time taxes collecting from the municipality
You answer the
corporation.
question first, and then you can answer whatever you think you want to answer. You answer first the court's question,
My lord.
then you can say whatever you want.
Rather, the impugned regulation is for the benefit of the public.
I know. So obviously it is a self-interest petition. It's not public interest.
It is apparent on the face of the record.
Ah. The counsel with the petitioners is unable to explain how this petition could be termed as a public interest litigation when
My lordship.
the petitioners are a private association of hospitals. Petitioner number one is an association of private hospitals, with petition number two being the general secretary of the association, and the relief being sought is exclusively for the benefit of the petitioners and not for the general public. Full stop. Therefore, this petition cannot be termed as a PIL. Paragraph. Secondly, petitioners are unable to explain they are challenging in 2023 a regulation of 2016. Full stop. The petition is silent. The arguments in the petition also do not offer any explanation for this delay. Paragraph. Permitting the petitioners to file a supplementary affidavit to explain the delay before the next date. The court directs that this petition be not numbered as a PIL petition. No, not be treated as a PIL petition. No, not be numbered as a PIL petition, but as an ordinary writ petition, and be listed before the roster bench on 11th May 2023.
Item number 2. My lord, I am challenging inaction of the OP number 3, my lord, who is not initiating any proceeding against the government land enclosures of OP number 4 and 5. In spite of our request, my lord, in our last request made by the said OP number 3 on 16th March 2023 at page 30, my lord, through registered post.
All right. The petitioner's representation, bracket extra 3, will be examined by the Tahsildar, Khaira, and after notice, the petitioners and opposite parties 4 and 5, and after giving them a hearing, the reasoned order shall be passed not later than 1st July 2023, and be made available to the parties within a week thereafter. The court clarifies it is not excluded.
Item number 3.
May I please, your lordships? My lord, other similar matters are posted to 22nd of June, my lord.
What is that other similar matters of the same appellant?
Same appellant, my lord.
All right. List along with?
Along with WA 54 of 2023 and 57 of 2023.
54 and 57 of 2023 on
22nd of June.
22nd June 2023. All right.
Another matter is also there, my lord, in the list, my lord. Item 53, my lord.
Okay.
53 also.
Same order.
My lord, same.
All right. All right.
Item number 4.
My lord, in this honorable court, I have challenged the order of learned single judge dated 1/2021 under Annexure 7 at page number 77 of writ opinion. My lord, that order was passed before admission of my writ petition in the same bench. And that was almost an interim order, direct me to vacate the railway quarters, which was under my occupation. And that vacation arose due to unlawful removal of my service, where I was under treatment at SB Netar Walotpur Cutoff for replacement of my artificial limb. My lord, I am a physically challenged person and I lost my right leg below knee in course of my duty in railway. And that removal was without serving me inquiry report, and still now I have not received inquiry report. And my main case is also today listed in another single bench of this honorable court. Sorry, another division bench of this court, this honorable court against the order of CAT. And today is hearing fixed. And I am in this court, I have requested for a continuation by railway quarter. Until now, I am residing in the railway quarter from last
How can you?
2013.
No, 2 or 3 things. Today, what is your age, sir?
My aim is I am residing in railway quarter.
1 minute, 1 minute.
My age is 63, my lord.
Can you continue as a railway servant?
No, my lord, I have been terminated since 2000.
No, I'm asking you, since you seem to be quite well versed,
Yes.
suppose you succeed in that litigation.
Yes, yes.
They'll put you back in service.
No, my lord.
They will not, no?
Yes.
So can you continue without being a railway employee? Can you continue in quarters?
My lord, I cannot continue. But my lord, I was
What is the date of this order? The single
of-
judge's order?
1/2/2021.
That is 2 years ago.
Yes, yes.
So
My,
despite this order, you have continued.
my lord, I am still under sick list, and there is a railway circular that when a person is under sick list, he cannot be removed.
So even if we today dismiss your appeal, you will anyway not vacate.
Yes, my lord.
Ah,
My
so
lord,
very-
my
Such a convenient thing, sir. Why are we wasting our time then?
my lord, my side, I am staying.
You see,
because-
you're already 63 years old. When were you removed from service?
My lord, I admit I am
No,
63
let's,
years old.
before you admit, we'll just know the facts, sir. We should know the facts, no?
My lord, although I have been removed,
When were you removed, sir?
my lord, I was removed and subsequently
No, date. When were you removed from service?
15/10/2012.
2012.
Yes, my
So
lord.
11 years ago.
My lord, that removal has been again reduced to compulsory retirement against.
It's okay. Compulsory retirement means also you cannot continue.
My lord, that is also gone. Compulsory retirement is not also valid today. And the order of single bench and the order of.
So when do you propose to vacate? You are now 63 years old. When do you propose to
My
vacate?
lord, last 10 years, I am not getting any salary, nor pension.
So you will not vacate then.
When that will be cleared, I will vacate.
When will it be cleared? Whenever. When you are 75 years old, if it's cleared, you will vacate
My
then.
lord, today hearing is there in the.
Okay, today nothing happens. Simply adjourn. You will not vacate.
If 2-3 months it will be cleared, I will vacate.
If it is not cleared, you will not vacate.
No, my lord, I will vacate.
When?
How shall
Which is the good day? Which is the good day for vacating?
My lord, where shall you move?
So if you are not able to move anywhere, you will continue railway quarters.
My lord, I have no salary, I have no pension,
Correct.
nothing else.
Correct.
How I shall leave, my lord?
So that's the law. If you do not have any of that, railway quarter is yours because one time you were a railway employee.
Further, my lord, another thing that quarter has will not be allotted to any other fellow.
You have already decided that.
My lord,
You have decided it will not get allotted to anyone.
no, my lord, I have not decided. Railway had decided.
This is for you for life.
That is.
They passed an order that this quarter is for you for life.
No, my lord, I will vacate. That will be dismantled. Not that will be allotted. That will be. I require for 2-3 months, my lord. When my case is last stage, and when it will be decided, and my.
Suppose the case is not decided, you will not vacate.
My lord, my pension is there, my discharge is there.
So irrespective, see, why do you need court orders, sir? Because single judge said he did not agree with you, which is why you're in appeal. Single judge did not agree with you, which is why you're in appeal.
No, my lord, notice has not been served on merit.
No, did single judge agree with you or disagree with you?
No. In the admission charge, he directed me to vacate.
That was 2 years ago.
Yes,
And you did not vacate.
my lord, there is no alternative.
No, so why do you need court order? See,
My lord, there is,
even if the court says vacate, you're not vacating, no?
my lord, there is no alternative.
Correct. So I'm saying, despite court asking you to vacate, you don't vacate. Railways asking you to vacate, you don't vacate. Why do you need court order? You have yourself decided. Sir, till cases are decided, I'm not vacating.
No, my
Whether order is against me, in my favor, you're saying no problem, sir. I will simply continue.
My lord, there is
Why do you need court orders, sir? You don't need court orders.
No, my lord, there is also rules there.
No. Sir, I'm just saying, sir, today we dismiss the appeal.
Yes, my lord.
You will say, where should I go? I will continue.
No, my lord, if it is only for use force, I will be bound to vacate.
How? You've decided. See,
I'll
you
go
said
to
just now that till my cases are decided, I will not vacate. You just now told us.
My lord, I have also cited one case of Honorable Supreme Court.
Which
One
says that despite losing in all courts, railway employee, ex-railway employee does not vacate. That's what Supreme Court said.
No, my lord. One IRS that Isapriya Bhatia versus Union of India.
What does it
In
say?
that case, 12 years he was terminated in the year 2012. And finally, his litigation was over in 2020. And he was again given 3 months time to vacate the water. And my case is still in my favor, not against me. My case on merit is still in my favor.
Courts have, you already decided. See, since you're very clear it is in your favor, why do you need court orders, sir?
My lord, I have enclosed court here. My lord, page 7, I must. Page number 37, my lord.
Yes.
There is one observation of learned single bench of this Honorable High Court.
Yes.
Considering the rival contentions of the parties, this court finds though the writ petition involves order of disciplinary authority, appellate authority, reviewing authority, and also at the higher level, subsequent to the disposal of a revision and review, but the petitioner's approach against the order of punishment and the reduction and confirmation thereof by the higher authorities to the State Commissioner of Orissa, Bhubaneswar, under the provisions of PW Act referred to here in the Bhubaneswar, and the decision of the State Commissioner of Bhubaneswar at Annexure 30, this court finds there is no adjudication of the proceeding involving the petitioner as of now by any competent authority.
Right.
Except the State Commissioner deciding that the proceeding initiated involving the disciplinary proceeding concerning the petitioner was not maintainable before the State Commissioner.
No.
That means, my
what
lord,
what we are concerning now is not your compulsory retirement, right? That is a separate proceeding.
Well, my lord, that is in this honorable court.
I know, it is in some other court, no? Sir?
Yes.
It's not in this court. It is in this matter. So this decision you should be citing in that case, correct?
No, my lord.
No.
I only want some
this decision you will not cite in that other court.
No. This
Why?
is separate. My lord,
No. When that case is called out, you will not cite this judgment.
my lord, this is quarter matter. That is service.
This what you read out is a quarter judgment. This what paragraph you read out is about quarters.
No.
So this paragraph you should be reading out in that case.
In my merit, my lord.
So that has nothing to do with this case today here.
Again, my lord, in the merit, the honorable State Commissioner, my lord, page number 68, my lord.
Yes.
You
give us a simple answer. Today when we dismiss your writ appeal, if we dismiss your writ appeal, will you vacate or you will not vacate?
My lord, if they will immediately use force and I will be vacated. I will go to road. There is no alternative.
Sorry?
If they will use force, then there is no...
No, Christopher, they will use force and all. They never used force against you for the last 2 years.
Yes, my lord. When this was on our stay, my lord. I was not illegally retaining. Honorable district judge given stay for entire period, my lord.
District judge gave you stay?
Yes, my lord.
No. After single judge dismissed your writ petition, district judge gave you stay?
No, Lord, my lord. I came to this court after dismissal of district judge Sambalpur for retention of my quarter. That is eviction proceeding.
And then when did this court dismiss your writ petition?
My lord, writ petition is still pending, not decided, my lord. Only interim order I was directed to vacate. And now the writ petition is still pending. That is.
So interim order was passed when, you tell us?
1-2, my lord. Annexure 7, my lord.
What is the date, sir?
1-2-2021.
After that, they used force against you?
No, my lord. Since the case is under sub judice, they have not used force. And beforehand, force was everything is there, my lord.
No. So they did not use force against you.
My lord, that liberty will be given, and I will.
No. Last 2 years, they did not use force against you.
No, my lord. Since the case is under sub judice, my lord.
Sorry?
Sub judice, my lord.
So they also decided with sub judice, despite dismissal of your application, they will not vacate you.
Moreover, my lord, that quarter will not be allowed.
Which is why I'm saying, sir, why do you need us? See, you seem to be very comfortable now. You're right now residing there, no?
My lord, I am residing.
And you have no plans to vacate.
Yes, my lord, I will vacate. I will.
When will you vacate, sir? When will you vacate?
If there is no alternative for that reason, I am residing.
No. See, you will only tell them.
Because, my lord, there
See,
is no
despite your applications being dismissed,
my lord.
you are able to convince them that because your writ petition is pending, you do not have to vacate.
For that reason, there is
Same
no
thing.
alternative,
I'm
my
sure when they ask you, you say, no, it is sub judice.
My lord.
They seem to agree with you. Despite your single judge saying that you have to vacate, you have not vacated.
Yes, no, my lord.
So they
there
are
is no
also,
alternative.
your railways are also very kind to you.
Yes, yes, my lord.
So why do you, what I'm saying is, this is irrespective of court orders.
No, my lord, they will release my salary, they will release my pension, they will release my discharge, then I will vacate, my lord.
That's
There
what,
is
you
no
have so
file.
many conditions, sir. So you have very clear in your mind, till so many things happen, you will not vacate.
No, my lord, nothing happened.
Correct. That's what we are also telling. Nothing has happened to you. You are comfortable.
No, my lord, I am staying.
Yes, that's what. You are staying there comfortably, sir. See, railway asked you to vacate, you did not vacate. Single judge asked you to vacate 2 years ago, you did not vacate. You are
Yeah, but
staying
there is no
comfortably
alternative.
there. That's what. I'm just saying. So when you're comfortably there, you don't need court orders.
I am waiting for court order, my lord.
You have to see, whenever you get negative court order, you do not obey.
Then there is no alternative. If
Correct. No, not obeying is not. See, according to you, there's no alternative but to disobey.
No, my lord, liberty may be given for
What? Liberty? More liberty you need for what?
My lord,
We can give you liberty to obey the order.
I will make arrangement, my lord.
We'll give you liberty to obey the order. You want that liberty, we'll give you. Liberty to obey the order. So far, you have not obeyed any order. Railway order, you did not obey.
You have not
District
obeyed.
judge order, you did not obey. Single
lord,
judge order, you did not obey. So now what liberty? Liberty only to obey.
My lord, my
We give you full liberty to obey all these orders.
my lord, my service matter, railway not to obey that order.
That's
Because
what. They will not obey, you will not obey, then what is the problem? No problem.
What should
Why do we need courts, sir? See, unnecessarily one court, district court wanted you to vacate. Single judge wanted you to vacate. You never vacated. Before that, railways wanted you to vacate. So we'll give you liberty to obey the orders now. So far, you have not obeyed. Correct?
My lord, there is no alternative. How shall you obey? My lord, I have to leave somewhere.
See, you will obey. You are saying, I will obey, sir. Whenever it's convenient to me, I will obey you. Sir.
Railway, there is provision for.
Whenever I decide I want to obey, I will obey you. Sir.
My lord, there is order for in the railway rules for retaining my DCIG.
Yes.
But everything is pending, my lord. Since the case is under sub judice.
So we'll have one less pending now. Today, now we'll dismiss this appeal. One less pending. Railways are very kind to you. Let them continue to be kind. That's the best way to do it. You say, despite the learned single judge dismissing.
My lord, liberty may be given to raise this issue in the single bench again. The case is pending, my lord.
Repetition, I don't know.
Case is still pending in a single bench. WPC 3 to answer.
Never listed after that, despite date being given. Never got listed after that. The state offices matter. The order dated 1st February 2021, passed by the learned single judge, purportedly dismissing IA number 1590/2021 in writ petition civil 3213 of 2021, declining to stay an order dated 22nd July 2013, passed by the State Officer, East Coast Railway, Sambalpur, requiring the, under section 5(1) of the public premises, eviction of unauthorized occupants Act 1971, PPE Act, requiring the appellant, who at that relevant time was a railway employee, to vacate railway quarter number AC by 17/1, type 2 at Sector D, Railway Colony, Sambalpur. Full stop. The learned single judge also declined to stay the operation of the appellate order dated 19 January 2021, passed by the District Judge, Sambalpur, in FAO number 13 of 2013, which dismissed the appeal filed by the present appellant against the eviction order passed by the estate officer. Paragraph. When the writ petition was listed first for hearing before the learned single judge on 1st February 2021, it was noticed that despite being removed from service, the appellant continued to be in occupation of the railway quarter in his favor. Full stop. The learned single judge observed, open quotation, even if he is no more in service and his service period has expired, he is forcefully occupying the quarter, full stop, therefore is liable to vacate the quarter, full stop, unquote. The above observation came about since the appellant was, even at the time of filing the writ petition, 61 years old. Full stop. He had been removed from service by an order dated 15th October 2012. Full stop. Therefore, by the time the matter was heard before the learned single judge, he had already ceased to be in service for approximately for over 8 years, and without any order in his favor in the separate proceedings in which he had challenged his removal from service, he continued to occupy the railway quarter. This prompted the learned single judge, by his order dated 1st February 2021, to direct the appellant to vacate the quarter by 28th February 2021, open quotation, failing which contempt proceedings shall be initiated against him for non-compliance with the order of the court. Paragraph. The learned single judge directed the case to be listed on 3rd March 2021. Paragraph. Although on a reading of the order, it is plain that it is IA number 1590 of 2021, which has been dismissed by the learned single judge, there is no mention of the said IA in the said impugned order. Paragraph. Be that as it may, from the record, it appears that the writ petition was listed again on 8 March 2021, when the court was informed that the present writ appeal had been filed by the appellant. Paragraph. A perusal of the present writ appeal reveals that the appeal was filed on 27th January 2021. Sorry, was filed on 12th February 2021. Full stop. On 8 March 2021, the learned single judge directed that writ petition civil 3213 of 2021 should be listed after the disposal of the present writ appeal. Paragraph. The present writ appeal has never been listed before the court till today, when it has been taken up in its usual course. Full stop. In other words, there has been no stay of the order of the learned single judge, which required the appellant to vacate the premises under his occupation. Paragraph. The appellant today is admittedly over 63 years old. Full stop. In response to a query whether he has obeyed the order of the learned single judge, the appellant answered in the negative. Full stop. When asked how he could justify not complying with any of the orders which were against him and continue to occupy the railway quarters despite having crossed the age of superannuation, the appellant simply answered that till such time the petition filed by him challenging the termination of his services is decided, he does not propose to vacate the quarter under his occupation. Full stop. In other words, the appellant is not considering the orders so far passed, either by the estate officer or by the district judge or by the learned single judge, as requiring him to vacate the quarters and his occupation. Full stop. It appears that the respondent railways has also not made any move against him, as disclosed by him before this court, to require him to vacate the quarters. Paragraph. In the circumstances, the court sees no justification for interfering with the impugned order of the learned single judge, while only observing that the continued occupation of the appellant of the quarters, despite ceasing to be a railway employee for over 10 years now, appears to be wholly unjustified. Stop. The writ appeal is accordingly dismissed. No, but don't call it. It is there for the single judge. Will continue. Writ petition civil 3213 of 2021 will now be listed before the learned single judge in the roster bench on 1st May 2023.
Item number 5.
May please, Your Lordship. Your Lordship, in the present matter, the present appellant has challenged the order passed by Honorable Single Judge in dated 15/7/2022, Your Lordship. That is at Annexure 8, page 53, Your Lordship. Your Lordship, the facts leading to the present writ appeal is that the present appellant had been selected as a successful Anganwadi worker earlier for the block of Chandamunda block of Binjarpur, Your Lordship. Thereafter, Your Lordship, the present opposite party number 5 has filed a Anganwadi miscase appeal before the opposite party number 2. That is at page number 6, Your Lordship. Annexure 6, page number 49, Your Lordship. The appeal was filed on the ground that despite the submission of the mark sheet, Your Lordship, of the 10th mark sheet, the opposite parties had not considered her candidature for the Anganwadi worker, Your Lordship. The learned opposite party number 2 was pleased to upheld that the submission of matriculation certificate is not necessary, and a mere mark sheet that has been issued by the headmaster will suffice. And the scrutiny committee had erred in rejecting her application, and that is why the present opposite party number 5 will be eligible for the said post, Your Lordship. Challenging the order of the opposite party number 2, Your Lordship, the present appellant had also approached this honorable court, Your Lordship. Your Lordship, the requirements of the eligibility criteria is there at page number 18, Your Lordship. Your Lordship, page number 18, it has been stipulated that the documents have to be submitted within the stipulated date, that is 26/7/2017, and the same cannot be accepted later on, Your Lordship. While the opposite party number 5, Your Lordship, before the scrutiny committee, she did not submit any matriculation certificate. She did not submit her original documents, Your Lordship.
No, she submitted her attested mark sheet.
Yes, Your Lordship, but the requirement was not that of attested mark sheet. The requirement was that of submission of matriculation certificate, Your Lordship.
Let's read that. What the single judge says.
Your Lordship, that is at page 20, Your Lordship.
No, I think the operative portion is para 26.
Yes, Your Lordship. Your Lordship, the stipulation of advertisement was submission of the matriculation mark sheet, Your Lordship, and that is to be
Why don't we read para 26 of the single judge?
As per the norms of selection of Anganwadi, the mark secured in the matriculation is of primary consideration, Your Lordship. On perusal of the materials on record, it is seen that admittedly the opposite party number 5 is more meritorious than the petitioner, and this court is persuaded to hold that the mark sheet submitted by the opposite party number 5, which were issued by the headmaster of the school, confirms the stipulation of the advertisement relating to submission of photostat copy of the mark sheet, Your Lordship. The selection committee, in rejecting her candidature, has virtually rewritten the stipulations relating to the submission of mark sheet to be submitted, which is expressly not permissible, Your Lordship.
So what did the selection committee do? Where is that order?
Your Lordship, the order of the selection committee is at page number 34, Your Lordship. 34 of the brief, Your Lordship.
Right.
Your Lordship, para 5, Your Lordship. Third last para from the bottom, para 5, Your Lordship, page number 34. Your Lordship, the last line says, Ranjita Pradhan's application, the present opposite party number 5, was rejected due to the non-attachment of HAC board mark sheet to her application, Your Lordship.
Why is that? This HSC board mark sheet is not correct, right? In the sense, she did attach a photostat mark sheet attested.
No, Your Lordship, she did not attach a photostat even. She simply gave a handwritten mark sheet that has been written by the headmaster and signed by the headmaster, Your Lordship.
No, that is whatever they give her, she has to attach. Say, she can't dictate to the headmaster, you better type it out.
Your Lordship, the same has been, she had submitted a mark sheet that had been virtually written by the headmaster saying that
virtually meaning what? He imagined the marks on his own?
No, Your Lordship. The marks are the same as that of what she has scored, Your Lordship.
No. So you're not disputing that she scored those marks.
No, Your Lordship.
So don't say you're making it appear as if the headmaster thought of some marks and simply handwrote some marks.
No, Your Lordship. That is not the case.
So you're not even challenging the genuineness of the mark sheet. You're not challenging the fact that she scored much higher marks than you did.
Yes, Your Lordship.
So what is the justification for rejecting?
Your Lordship, when the mark sheet that has been submitted by her, Your Lordship, if that is given into effect, Your Lordship, then that is directly violating my right.
What's
under Article
right?
14
She
and
scored
16.
higher marks than you. Where's the question of violating your right?
Your Lordship, but then there's the
Denying her would be violating her right, correct?
Lordship,
When she scored higher marks than you.
Your Lordship, but there's a certain procedure that needs to be followed.
What is that procedure aimed at?
That procedure is submission.
To find out who is the more meritorious candidate. Any selection, that's the aim
Yes,
of the
sir.
selection.
Yes,
Correct. So
Your Lordship, but then there's a mode of submission of the documents also, and certain documents authorized by.
if it impinges on the genuineness of the document, suppose the original reads that she's got only some 20 marks, what she has submitted shows she scored 40 marks.
Your Lordship,
Then you can say the copy does not match the original. You have to reject the copy.
Your Lordship, but she was given that 7 days time to produce her original mark sheet also. So the whole point of having a scrutiny committee is while applying whatever documents you are submitting, when you are producing the original documents, the scrutiny committee will compare the same and verify your candidature, Your Lordship. But in non-submission of the original certificate at that very particular time also, Your Lordship, the scrutiny committee has...
No, did she submit the original at all or she did
No,
not?
Your Lordship, she did not submit the original at all. She has rather submitted her +2 certificate. She has never submitted her matriculation certificate, even at the time of final verification.
Let's read the order of the appellate authority.
Yes, Your Lordship. Lordship, Parrot 20 is the...
No, page, I think the running page is 49.
Yes. Gone through the...
Oh, there is a paragraph which says the short history.
The short history of the appeal is that the appellant during filing of her application for the post of Anganwadi worker in Chandamunda Anganwadi Center has filed mark sheet of matriculation issued by the headmaster Sri Jagannath Vidya Mandir Rahasoi instead of the board. But on the date of verification of original certificate of the candidate, she has filed the original board mark sheet certificate having the same mark
So
as...
you gave us a wrong answer.
Your Lordship, but...
On the date of verification, she did produce the original certificate.
No,
You
Your
said she never produced the original. That's what you just saw submitted.
Yes, Your Lordship, because in the counter that has been submitted...
No. This is the order.
Yes, Your Lordship, this is... despite the fact that even the opposite party number 1, that is the CDPO, Your Lordship, he has submitted that the Council of Secondary Education relates to +2 marks, Your Lordship. But she has never submitted her board. That is the recording in the scrutiny committee
No.
documents
But
also.
you are. When we asked you, did she produce the original? You said no. She never produced any original, which is a wrong statement.
Your Lordship, that is what is...
Why do you make a wrong statement? The sense is obvious that she produced an original.
I may be pardoned, Your Lordship, but in the proceedings of the meetings of the committee...
No. This is what we're reading from the order. Continue reading. So
Yes,
she
sir.
did produce verification of the original certificate. She has filed the original board mark sheet certificate. Read
But-
that.
in response to the notice, which has not been considered by the selection committee, taking plea that she has not filed the copy of the original mark sheet of the board during filing of her application.
Application.
Your Lordship, this is the contention of the
Read on.
Though she has been secured 483 marks, the selection committee selected the respondent who has secured only 230 marks. In response to the notices, the learned advocate for the respondent number 1 filed written statements wherein he stated that the appellant has not filed the copy of the original board mark sheet during filing of her application and for verification of her original board mark sheet, by which she has not been selected by the selection committee. The CDPO Binjarpur as respondent number 1 has also submitted her written statement with documents and the Anganwadi workers marks calculation sheet of Chandamunda 3 Anganwadi Center, wherein it is stated that the appellant has not attached the original board
That's
mark
right.
sheet.
Attaching is one thing. What she attached with her application was the photocopy. But at the time of verification, they produced the original.
Your Lordship, it is the first paragraph.
This is one hyper-technical thing that, you should have attached the original with your application.
No, Your Lordship, that is
What
not...
the advertisement requires is only a attested photocopy to be attached. So during the time of verification, she produces the original. And you say, no, with your application, you did not attach it and therefore we are rejecting.
Your Lordship, but that is the thing, Your Lordship. In the time of verification also, the CDPO itself has given a written statement that the original certificates were
He
not
did
ready.
consider. See, she produced it. He does not consider as saying you did not produce it along with your application.
And also, Your Lordship, thereafter also, after...
In fact, this is a classic case where you simply throw it out on a hyper-technicality, despite knowing that this is not one forged certificate, this is not a fabricated document.
Your Lordship, but her board certificates also have never gotten into record, Your Lordship.
No. You don't take it on record. What is this brought on record? At the time of verification, you produce the original, you say, no, I will not consider
Your
it.
Lordship, that is what is the stand of the CDPO, Your Lordship.
Yes, which is what is wrong, which is what is being challenged.
Yes, Your Lordship, but that
How is it justified? The CDPO, how can he throw out when the original is being produced? He says, I won't look into it.
Your Lordship, but in the original certificate also, they have produced the certificate of Council of Secondary Education, Your Lordship. That is a +2 mark.
Produce whichever is the exam you took.
Your Lordship, but that was supposed to be the Board of Secondary Education
No,
certificate, Your Lordship.
that's not what the advertisement says. It doesn't, in fact, the single judge correctly points out, it does not stipulate that it has to be this board or that board or anything.
Your Lordship, that is what is the difference. Board of Secondary Education
No.
relates to 10th standard, Your Lordship, and
Or-
Council of Secondary Education relates to +2, Your Lordship.
Or
Your Lordship, and in the advertisement also, it has been stipulated that it is the matriculation certificate that needs to be taken care of.
correct.
But here the matriculation certificate, instead of matriculation certificate,
She has passed the matriculation, madam. You're not able to overcome that fact. She's
Your
gotten far more marks than you have.
Your Lordship,
This is the problem.
that is what is the contention. Then she
Yes,
should have
yes.
submitted the original certificate.
It's all
Your
a
Lordship.
hyper-technicality. You say the challenge in the present writ appeal is to an order dated 15 July 2022 passed by the learned single judge, allowing writ petition civil 4518 of 2019 filed by respondent number 5, whereby she had questioned the selection of the present appellant as Anganwadi worker, bracket AWW of the Chandamunda Anganwadi Center, bracket AWC, pursuant to an advertisement issued on 27 June 2017. Paragraph. The selection of the present appellant had been assailed by respondent 5 in an appeal filed before the Additional District Magistrate, bracket ADM, which came to be dismissed by an order dated
15/7.
no, which came to be allowed. Sorry. By an order dated 13 February 2019. You got to stay in the writ petition.
Your Lordship.
When the writ petition was filed, did you get a stay in your favor?
No, Your Lordship, there was no stay.
So you've been out of service since then.
Yes, Your Lordship.
I see. The learned ADM noted in the impute in the said order that the selection committee had wrongly failed to consider the original mark sheet, matriculation mark sheet produced by respondent 5 at the time of verification, only because she had not enclosed it with her application. Full stop. Admittedly, respondent 5 scored 483 marks in her matriculation, whereas the present appellant scored only 230 marks. Full stop. Holding that the selection committee fell in error in not allowing respondent 5 not considering the original board mark sheet submitted by respondent 5 during verification. The ADM set aside the orders engaging the present appellant and directed that appropriate orders should be passed by the selection committee as regards engagement of respondent 5. Paragraph. In the writ petition filed by the present appellant, it was again urged that respondent 5 ought to have produced the original mark sheet along with the application. Stop. It was also sought to be contended that the mark sheet submitted at the stage of verification was at variance with the original mark sheet and therefore could not have been considered. Paragraph. The learned single judge noted that the requirement of the advertisement was single quotes matriculation certificate and mark list, unquote. The revised guidelines required the production of the revised guidelines referred specifically to the marks secured in matriculation, which was the minimum educational qualification that was prescribed. Paragraph. The learned single judge found that the selection committee rejected the candidature of respondent 5, stating, open quotation, no original board mark sheet attached on application, rejected, unquote. Paragraph. The learned single judge found no merit in the contention of the appellant that since the mark list that was submitted was not issued by the Board of Secondary Education, Odisha, but prepared by the principal of the institution and signed by him, it could not have been considered. Full stop. The learned single judge noted that the stipulation regarding submission of documents did not require that the mark sheet has to be necessarily issued by the board, and therefore the selection committee had misinterpreted the stipulation. Full stop. In para 21, the learned single judge noted as under. Reproduce the whole of 21. Paragraph. In other words, what was issued by the headmaster tallied with the mark sheet issued by the Board of Secondary Education, and there was no variance whatsoever. Paragraph. Learned counsel for the appellant reiterated the stand taken throughout, namely that respondent 5 ought to have produced the certificate, matriculation certificate, as well as the original mark sheet issued by the board along with the application. So, the court is unable to accept the above plea, since factually it has been demonstrated that the copy of the mark sheet enclosed with the application tallied with the original which was submitted at the time of verification. Admittedly, response number 5 is more meritorious, going by the marks secured in the matriculation examination. More meritorious than the appellant, going by the marks secured in the matriculation examination. In the circumstances, the court is unable to find any error having been committed by the single judge in dismissing the petition filed by the appellant. The appeal is accordingly dismissed.
Item number 6.
Lord, we have filed the counter affidavit. Lordship has directed unless it is filed, the 25,000 cost, we have filed it on time.
Yes, please. Do you want to file a rejoinder or?
The rejoinder had been filed yesterday, my lord.
Oh,
Sought a copy in the connected matter.
I have not sought.
In the yes, it has been solved in the Advocate General Office, my lord.
In which, oh, you have
It
sought.
appears that, you see, the counter affidavit has been filed in writ petition civil 27662 of 2021. Paragraph, Mr. Jena, learned counsel appearing. The companion writ petition civil 19482 of 2021 states that.
He is in Alokpati
In
case.
the connected matter.
That's right. The connected only accepted. States that he has filed a rejoinder in writ petition civil 19482 of 2021 only yesterday. Stop the same be placed on record and a copy thereof also be served on learned additional government advocate. List on 23rd June. No, sorry, 22nd June. 22nd June.
My humble prayer, Your Lordship, is that the Rourkela Development Authority has filed a counter in the connected matter. But the same counter is not facilitated to me in my case, my lord, which is vital in my case also. Because the same order is included in both the cases.
Rourkela Development Authority will serve a copy of the counter affidavit filed by it in writ petition civil 19482 of 2021 to the counsel of the petitioner in writ petition civil 27662.
I think we have filed, we have solved the copy on Mr. Das also.
No.
That is the counter by the Tahsil.
Rourkela Development Authority is
Counter by the
Oh,
counter of the RDA.
I see, I'm sorry.
Right.
Item number 7.
I'm grateful, Your Lordship, deeply obliged.
Item 7, we are referring for OP number 5, my lord.
And Lord, 7 and 97
are same.
both are
97
same. We will file counter,
correct.
there it needs a hearing. Can't be six.
But it is on 20th March. They have
Yes,
not
this is the
filed
second
counter.
time I'm taking last chance, Your Lordship. Now, there is no urgency. There is
yes, it's urgency.
there is no urgency in the matter. It is only quarrel between two shop owners.
But here the Sarpanch is repeatedly
Sarpanch-
for last 3 years is objecting. Even then he's a. Now the
Running
policy has come, excise policy. They have categorically stated where the Gram Sabha has passed resolution, the license should not be renewed.
I think notice is still not gone in this.
No, in one case.
But it was
notice is-
listed on 20th. They said that it is a connected matter is on 18th, so that's why
In that
Lordship
second
directed.
matter, Your Lordship can issue notice and fix it.
Both matters,
Date.
I think both matters issue notice.
Yes,
Man,
yes.
issue
97
notice in both
notices issued.
matters.
In seven notice has not been issued.
97.
93, it's already been issued.
97 already issued.
Yes, it's complete. No, pleadings
Seven,
complete.
you say notice.
Pleadings complete
He
there.
accepts, Mr. Mohanty accepts notice for opposite parties 1 to 4. Who accepts for 5?
Yes, my lord.
Counter affidavit will be filed.
No. She accepts for respondent number 5, opposite party number 5. Replies be filed within 8 weeks, rejoined the next day. And then in the other matter, 93.
97.
97.
97.
See,
97 pleadings complete.
learned AGA. Section is granted. '97, there are 2 matters.
Yes, my lord. 2 matters pleadings complete. Into entire 2 matters. Counter, resender, everything has been filed long since.
Oh, okay. In 97, you just simply say list along with item number 7 on
Can it be on?
27 June.
Can it be first week of June?
27th.
First week of June.
July.
First week of June is
June.
holiday.
The holidays.
Oh, sorry,
Summer vacation.
my lord.
Right.
Sorry. Item number 8.
8, my lord, magistrate. My lord, it is a PIL matter, my lord. The government land has been encroached by the OP number 5
and he is trying to construct the shop room, and which is adjacent to temple of the Lord Chandrasekhar Dev, my lord. And there is a Dola Mandap is also. And in spite of representation filed by the petitioners, he is not taking any action. And lastly, the committee of the Chandrasekhar Puja committee has given representation under Annexure 4 series.
1 minute, sir. Petitioner's representation Annexure 4 will be examined by the Tahsildar Balipatna, and after notice to the petitioners and opposite party number 5 and giving them a hearing, the reasoned order shall be passed not later than 1st July and be communicated to the parties within a week thereafter. The court clarifies it is not expressed to you.
Item number 9.
Again,
My lord, this is a PL matter, my lord.
Annexure 3
My lord.
shall be considered by the opposite party. Video, how many videos, sir? Some 5 videos you have completed. Which video? 5, 6, 7, 8 are all videos.
My lord, open number 2, my lord.
Collector.
My lord, collector Noyagad, my lord. Open number 2, my lord. My lord, that is coming with 3 blocks, my lord.
To the petitioner. And opposite party number 3 and 9. And after giving them a hearing, a reasoned order shall be passed not later than 1st July and be communicated within a week thereafter. Right.
Item number 10.
Bless me.
May I take this?
What's the
Filing this appeal delay 30 days, your lordship.
Yeah, tell us what the matter is about.
My lord.
Tell us about the matter. Tell us about the matter.
Yes, my lord. Challenging the order passed by the Honorable Single Judge under Annexure 6, page 39.
It's an appeal.
Order is available is to file the appeal.
Avail the appeal.
Your lordship, challenging the order passed by the Tahsildar, file the present appellant, file the writ application before this Honorable Court.
What does single judge ask you to do?
So the order is applicable. The grounds of the appellant, the order passed by the Tahsildar has not sustainable. The Tahsildar has already lost his jurisdiction. Under Annexure, your lordship kindly.
Why can't you file an appeal and raise that in the appeal?
Your lordship kindly see the running page 21.
Sir, why can't we file an appeal and address that in the appropriate appellate forum?
Initially, the land encroachment case issued against the present appellant, and the order passed by the Tahsildar already land encroachment case is closed and directed to settle the land in favor in the name of the appellant and issued ROR in favor of the appellant under Annexure.
Those points
Annexure 2
before the appellate authority.
Under Annexure 2, page 19. The order passed by the Tahsildar in land encroachment case number 25 of 1980. Therefore, the appellant before your lordship that the Tahsildar has already lost his jurisdiction. That the Tahsildar, the state authority should have been filed an appeal challenging the order passed in land encroachment case number 25 of 1980. Instead of that, your lordship, running page 19.
Yes. What else, sir?
Running page 19, your lordship. May I read your lordship?
Yes.
SR back the encroacher is present on call, gone through the ROR, Thorodapalli. The land bearing 310 measuring 1 acre 130 decimals is recorded as Gochara under Rakhita Khata 141 with note of Jabardakla in the name of the encroacher's father, A. Narasimhalu. The encroachment is noted as continuous since 1940. After the death of A. Narasimhalu, his son, the encroacher is cultivating the land. The plot corresponds to Sabik number 120 as seen from the Adangal of 1961. The encroachment was also treated unobjectionable. The encroacher is having 73 cents of land. He submits that the records which were shown to the settlement by his late father were all burnt during fire accident, along with all his belongings. Inquired from the villagers of Thorodapalli who were present at the camp court, they confirmed the long-standing occupation of the land by the encroacher's family for over 40 years. According to the government, instruction for confirming adverse possession where no record are available, the entry in the ROR is to be accepted. Since the case land is under occupation of the encroacher's family since 1940 and the occupation was treated unobjectionable in the part Adangal entry 1961, I am satisfied that the encroachers as successors in interest has perfected adverse possession of the land. Hence, the case is not tenable under the provision of OPL Act under section 13 of the OPL Act. The encroacher is to be given royalty status for the case land and the rent has to be fixed from the date of 1940. Transfer the file to the court of Tahsildar for fixing the rent. The order passed by the Tahsildar, the then Tahsildar in OPL case number 25 of 1980. Inadvertently, when the Hala was published, the land was again recorded under the government khata. Therefore, petitioner filed an application before the Tahsildar. Thereafter, challenging the same writ has been filed and appeal also filed. The order passed by this honorable court to dispose of the representation of the petitioner as per the order passed by the Tahsildar under Annexure 2 in the application of 25 of 1980. In spite of that, the Tahsildar has rejected my representation, overruling the order passed by the self-same authority in the land encroachment case.
And that order is appealable order. In as much as the impugned order has only relegated the appellate to the remedy of his statutory appeal against the order of the Tahsildar which was challenged in writ petition. No prejudice can be said to be caused to the appellant on that score. Accordingly, the court finds no infirmity in the impugned order. The writ appeals dismissed.
Item 11.
May I submit your lordship? Delay.
You don't have to say anything, sir. Now you know.
My 8th May sort of parade.
Sorry.
Item number 12.
25th April mal DLR. All right.
Item number 13.
11th May mal promotion during pendency of the vigilance case.
Right.
Item number 14.
Memo taken on record. Dismissed as infractions.
Item 15.
15 is yours.
15.
16.
15.
State is opposite.
No. 15.
Sorry. That similar matter also was fixed to 11th May.
Or
Read appeal number 682 of 2022.
Along with 682 of 22. All right.
Item 16.
None of this.
Item number 17.
Same order.
Item 18.
Item 18, my lord, Pavitra Viswal case, Lordship has been pleased to grant us liberty to withdraw to file a review application.
All right. Disposed of has withdrawn with liberty to file a review petition.
Item number 19.
19, my lord, Sattapada case, my lord, 8th of May.
Item number 20.
20, 21, 22, 23, my lord, 25th of April. DLR regulation matter.
Item number 24.
24, my Sattapada, 8th of May.
Item 25.
My lord, item 25 has become infructuous, madam.
Disposed of his infractions.
Item number 26.
26 rehabilitation 30th August.
Item number 27.
27 Sattapada 8th May.
Right.
Item number 28.
DLR 25th April, man.
Item 29.
May I please, Your Lordship. My Lord, the present appellant has challenged the order of Honorable Single Judge at page 44, Your Lordship. The matter has been dismissed on the technical ground, my Lord, on the ground of delay. It is stated that though the order dated 4th July 2017 was assailed by before Honorable Single Judge.
This order is passed in a CMP that under Article 227 that your Lordship is not entertaining any writ appeal against the order of the
My Lord, I conscious about the law, but as because this is dismissed on the ground of technicality for that.
Technicality. So delay is not technicality. Delay and all has to be properly explained. Delay is not a mere technicality.
My Lord, what happened? The original petitioner was died in the meantime, and the substitution petition was pending before the learned trial
All
court.
this happened in
Three
the
years,
civil
my
suit, correct?
My Lord. Sorry, my Lord.
All this happened in the civil suit, na?
Civil suit.
Yes, Your Lordship.
Arising out of an interim order passed in a civil suit.
Somehow
Then
you are able to hear more clearly than this side.
Yes, yes.
No, the speaker this side is better than that side then. Whenever we ask this side, they never get the. Two of us have to ask, but you seem to have it clearly. I don't know how that is possible. All right.
My Lord, the appeal was dismissed on the appeal prepared by the father of the present petitioners was dismissed for default. Thereafter, the father of the petitioner filed a CMA application for restoration of that appeal, my Lord. Thereafter, in the meantime, due to technicality fault also, the appeal was abated against two of the opposite party before the lower appellate court, my Lord. Assailing that order, the present petitions challenged that order before Honorable Single Judge, my Lord. And the order dated 4th July 2017 was assailed before this Honorable Court.
When?
Before the civil judge.
When?
My Lord. My Lord.
When was it assailed, sir?
My Lord, in the year 2020. Your
How many years after the order in the CM?
After 3 years, Your Lordship.
So you are saying don't ask me to explain any delay.
My Lord, the civil right of the petitioner is going, my Lord, for that reason.
So the ordinary 3 years, 3 years delay becomes technical.
No, my Lord.
All right. The challenge in the present writ appeal is to an order dated 29/11/2021 passed by the learned single judge, dismissing CMP number 689 of 2020 filed by the appellate on the ground of delay in filing the writ petition to question an order passed on 4 July 2017 by the district judge, Nayagarh, dismissing CMA number 12 of 2009, which was an application for substitution of the legal heirs of the plaintiff, is it? Of the defendant?
Plaintiff, my Lord.
Legal heirs of the plaintiff. No.
Sorry, my Lord, I could not drop.
Opposite party number 4 was the defendant, correct?
Yes, Your Lordship.
Legal heirs of the defendant. In civil suit number.
Title suit number 6 of 2001, Your Lordship.
Title suit number 6 of 2001, pending in the court of the
Additional Civil Judge, Junior Division, Khandapada.
the court of the Additional Civil Judge, Junior Division, Khandapada. Paragraph. There are two. See, the present writ appeal against an order passed by the single judge in exercise of jurisdiction under Article 227 of the Constitution is not maintainable by virtue of the judgment of the full bench of this court. In Muhammad Saud versus Dr. Sheikh Mahfouz and another 2008 2 OLR bracket FB 725, which has been affirmed by the Supreme Court. And same cost 2010-13 SEC 517. Paragraph. Even on merits, the learned single judge was perfectly justified requiring the appellant to explain the delay of 3 years in filing the CMP. Consequently, the present writ appeal is dismissed.
Item number 30. Item 30.
Given this similar. Lordship dismissed similar cases.
All right. Same. All right.
Item 31.
May. I am for the appellant one. In this case, the petition has prayed for promotion to the rank of Havildar as per Policy Order number 288/90, Bahadi Annexure 1, page 28, my lord. During, my lord, kindly see. During pendency of this, during pendency consideration of promotion of the case of the petitioner, another circular has come, my lord, Bahadi Annexure 2, Policy Order number 302/2010, and some juniors have got promotion by virtue of that this circular 302/10, my lord, without considering my case for promotion in accordance with PCO number 288/90. Then I approach the learned tribunal. My lord, kindly see the order of the Honorable Single Judge, page 36, my lord. They have taken time for filing counter since 2010 without filing counter in the writ petition by wrong submission made by the learned State Council. The writ petition has been disposed as infructuous, my lord.
You did not get promotion.
No, I got promotion later on in the year 2012. But my claim is that when my juniors have got promotion to the rank of Havildar, I may be
promotion.
My lord.
When did they get promotion?
They got promotion in the year 2010, my lord.
So also the petitioner.
You also got.
No, I got promotion in the year 2012, my lord.
No.
They are much junior to me, my lord. And without
Para 4, Lordship, see page 36.
That's right.
It is wrongly mentioned, my lord. It is in statement made by the State Council, but I got promotion in the year 2012, my lord. I have stated my the writ appeal, my lord.
Sir, counsel for the appellant maintains that it was wrongly submitted by the government advocate before the additional government advocate, by the standing counsel for the government before the learned single judge, that the appellant had got promotion in 2010 itself, when in fact he got it only in 2012. Full stop. His prayer in the writ petition, according to him, was that he should have got promotion from the same year as his juniors. Paragraph. Since the impugned order appears to have not recorded the above submission, consider the above submission, the court permits the appellant to withdraw the present writ appeal to file a review petition for the learned single judge in accordance with law. The appeal is disposed of in the above terms.
32.
Next matter same.
30. Next matter
Same. All right.
Item 33.
My lord, 33, some defect has already been pointed out. I want to remove the defect within a week or two. Thereafter, matter to be taken.
All right.
Next matter.
Just on 5th July, defects be removed.
It's 34 also same. 34 also same.
All right.
Item 35.
35 on me push das can pass over.
All right.
Item 36.
36. Without issuing notice, review order has been passed, and in similar matter, notice has been issued and posted to 12th July. The Lordship 42 also same. Item 42.
36 and 42, same orders. 12 July.
Same. Item 37. 37.
37 by not 14-9. It's a work charge employment.
38.
May plus. Because some defects are there, some time may be granted to remove the defects.
21st June, defects be cured.
Item 39. 39.
Well, it was picked 6th July. I'm giving the copy.
Yes.
Item 40.
25th April, TLR.
Item 41.
25th April. All.
Item 43.
Forty-four.
43. 43 approved mentioned 32. 43.
All right. Along 43.
Your Lordship, item 43 similar to item 36.
42. Item number 42.
Manifest.
Item number 44.
Item 44 minutes, there is some defect minutes.
All right. Defects be cured.
Item 46. Item 47.
The author of the learned single judge is under challenge before your lordships on the ground that section 20 of the Right to Information Act imposes that the commission is required to impose penalty on the hearing the public information officer, my lord. But I ordered the information commission, though came to a conclusion that the public information officer has not provided the information within the stipulated time, but it did not impose any penalty. But the word mentioned in section 20 is, my lord, I have quoted it page number 6 of the writ appeal, my lord, that the commission shall impose a penalty of 250 rupees each day till application is received or information is furnished, my lord. But in the case in hand, the commission failed to comply with the section 20 in letter and spirit, and that was challenged before this honorable court, and the learned single judge, without taking into the materiality of the aspects, disposed of the matter, that it is within the.
Did you get the information or you did not get it?
And I will take instruction whether they have been supplied to.
No, please. There's no need for that. By now you should have known it. You see, the impugn order of the learned single judge declines to interfere with the decision dated 25th May 2022 of the Odisha Information Commission of Bhubaneswar in second appeal number 509 of 2018, whereby while directing the public information officer of the Regional Directorate of Education to provide information sought by the present appellant in Form A, no penalty was imposed. Paragraph. Having heard learned counsel for the appellant, the court is not inclined to interfere with the impugn order of the single judge on merits. No grounds have been made out for interference. Stop. Accordingly, the appeal is dismissed.
Item number 48.
25th April.
Right.
Item number 49.
Item 49 for the opposite party, they have already complied the order of this honorable court and first the engagement order issued, my lord.
49.
Your lordship.
Counsel for the respondent has
After
produced
file
before
of
the court
contemplation, they have complied the order of this honorable court.
the order complying with the impugn order of the learned single judge. In that way, matter has been rendered infractions and is disposed of as such.
In that matter, I will take instruction because Lordship has seen that order.
It's all implemented completely.
Because there is a case, my lord, what has happened. The PH category, the appellate committee has found that he is 2% physically handicapped.
Whatever, sir. Do not interfere. Yes.
Item 50.
Obligement.
Item 50 some defects are there, all removal to explore.
22nd June, defects be cured.
Item 51.
51 14th September. 14th September.
Item 52.
Lordship, may kindly permit me to remove the defects within a week, Lord.
23rd. No, you say 26th June. Defects be cured.
Item number 54.
May I please, my lord? My lord, in the instant case, the facts before writ petition OAC is that, my lord, while the appellant was continuing as classical teacher, my lord, efficiently, on the instance of the employer, my lord, at the fag end of his service career, they alternate the date of birth of the appellant, and he got prematurely retired on 29/2/2016 instead of 31/3/2020, my lord. They have illegally superannuated the petitioner, for which writ petition, this WPC OSU was filed, my lord. Though the Honorable Single Judge relied on Binapani Dei case, my lord, in the impugned judgment, but the Honorable Single Judge remitted the matter to the opposite party number 3 for providing fresh opportunity of hearing, which is not the case of the Binapani Dei case, my lord. My lord, kindly have a glance to the page 19 of the impugned order.
Yes.
My lord, it is a rejoinder at para 6, my lord. A rejoinder affidavit was filed by the petitioner by enclosing the request made before the District Education Officer Baleswar, and with a prayer to take appropriate steps as the transfer certificate in which date of birth is indicated as 1/3/1956 was issued prior to the petitioner having passed the said Madhyama examination. It is also submitted that the said transfer certificate was issued in favor of one Sarat Chandra Satpathy, not in the name of Sarat Chandra Satpathy. In the rejoinder, it is also submitted that after submission of the documents by the petitioner pursuant to the notice issued under Annexure B/3, no further communication or intimation was issued to the petitioner, and also after the letter issued by the Headmaster B.M. Ragurai High School on 31/10/2017 as well as on 10/11/17. The petitioner was relieved from his service with effect from 29/2/2016 by order dated 1/11/2017, basing in the report dated 31/10/2017. It is further submitted that the said action was taken by the opposite party number 3 without giving a reasonable opportunity of hearing to the petitioner and without issuing so cause. Since principle of natural justice has not been followed prior to the issuance of the impugned order, the said order is liable to be set aside. Then the next para. Mrs. Patnaik, in support of her aforesaid stand, relied on a decision of the Honorable Apex Court in the case of State of Odisha versus Dr. Mrs. Binapani Dei case and others. In the said decision, the Honorable Apex Court held as follows. It is true that some preliminary inquiry was made by Dr. S. Mitra, but the report of that inquiry officer was never disclosed to the first respondent. Thereafter, the first respondent was required to show cause why April 16, 1907 should not be accepted as the date of birth, and without recording any evidence, the order was passed. We think that such an inquiry and decision were contrary to the basic concept of justice and cannot have any value. It is true that the order is administrative in character, but even an administrative order which involves civil consequences, as already stated, must be made consistently with the rules of natural justice after informing the first respondent of the case of the state, the evidence in support thereof, and after giving an opportunity to the first respondent of being heard and meeting or explaining the evidence. No such steps were admittedly taken. The High Court was, in our judgment, right in setting aside the order of the state, my lord. My lord, relying on this, though the impugned order was set aside, but the matter was remitted back. My lord,
how is that prejudicial to you?
My lord, prejudice is that, my lord, the petitioner had approached this honorable court since he was prematurely retired, my lord, without giving any opportunity of hearing.
And now the
my lord, now
judge
he
gives you
has
that
got,
opportunity.
my lord, he has got superannuated, my lord.
So what?
My lord, my only submission is that when the Honorable Single Judge has relied upon Binapani Dei case, but nowhere in Binapani Dei case, the case has been remitted back to the authority, my lord, because my all consequential benefits are lying there and it will take longer, my lord.
No, it will be time bound.
My lord, when it is prima facie telltale, no opportunity of hearing was given.
Time bound. It's to be completed within 6 months.
My lord,
The
My
last
lord,
line.
because if
Up
Bina,
to para 9, last line.
yes, my lord, yes, my lord, I'm,
Excise will become-
my lord, because Bina Panidei case, then it is not
It's
the,
developed since then.
my lord, it is clearly telltale in Bina Panidei case.
Madam, the law has developed since then.
My lord, this is not a disciplinary proceeding. Where it has been recited, it has to be sent back to that stage.
All right. All right. That's it. That's
My
the only
lord, because, my lord, this is a classical teacher, my lord, and he's really struggled hard for this, my lord.
Or-
And on the basis of this Bina Panidei case, it has been, though it has been impugned order has been set aside,
Right.
but there is no point and no reason assigned why it will be remitted back to the opposite party number
Only
3.
to elicit the truth. Somebody, you have to be given an opportunity. You're complaining that you were not given an opportunity. The single judge has given you that opportunity.
My lord, now
you
they
are
will
saying,
be more clever.
I don't want an opportunity.
My lord, now they will be more clever. At the fag end of my service career,
Oh.
they have raised
What is this
this.
more clever and all? Truth has to come out.
My lord,
That's all.
I have also
Yes.
cited one judgment, my lord, where the employer cannot raise this issue with regard to dispute with relating to date of birth.
All right.
That has also not taken into consideration
All right.
because I have given written note of submission also.
All right.
It is also appended to that, my
Oh.
lord, that judgment.
Oh.
That is the recent judgment, my lord.
All right. So the challenge in the present petition, the present appeal, is to both the original order dated 14 July 2022 passed by the learned single judge, disposing of writ petition civil OA number 1871 of 2017, as well as the subsequent order dated 2nd January 2023 passed by the learned single judge dismissing the appellants are the BWPET number 185/2022. Agreed by his being relieved from the post of classical teacher by an order dated 1st November 2017 passed by the district education officer, taking his date of birth to be 1st March 1956. The appellant filed the aforementioned writ petition, aforementioned petition initially before the Orissa Administrative Tribunal and after its abolished, renumbered as WPC bracket OA number 1871 of 2017. Full stop. The learned single judge has agreed with the appellant that the said order could not have been passed without affording the appellant an opportunity of being heard, particularly since the order was passed on the basis of a report elicited from the headmaster of the high school, which had issued the school leaving certificate, in which the date of birth of the appellant had been indicated as 1st March 1956. In the counterfoil, but as 1st March 1960 in the certificate itself. Paragraph. In passing the above order, in the learned single judge has, while disposing of the writ petition, by setting aside the order dated 1st November 2017, directed the district education officer Bhadrak Circle to give the appellant a reasonable opportunity of being heard and to pass a fresh order and to complete the entire exercise within a period of 6 months. The stop reference was made to the decision of the Supreme Court in State of Orissa versus Dr. Ms. Bina Peniti, AIR 1967 SC 1269, paragraph. Counsel, the appellant is aggrieved by the above direction, since the decision in Binapani De Supra simply set aside the order having adverse civil consequences on the grounds of violation of principles of natural justice and did not remit the matter to the authority for a fresh decision. Full stop. It is contended that since the appellant has already superannuated, such an exercise was unwarranted. Paragraph. Since the appellant was aggrieved by the order dated 1st November 2017 having been passed in violation of the principles of natural justice, the appellant cannot be heard to complain about an opportunity being granted to the appellant to be heard and for a decision to be passed after such hearing afresh. Full stop. The appellant would be given the materials on the basis of which doubts have been raised about the date of birth as disclosed by him initially. Full stop. The appellant cannot refuse to avail of such an opportunity so that the truth comes out. Court therefore sees no prejudice being caused whatsoever to the appellant by the aforementioned direction issued by the learned single judge. Paragraph. It is then contended that the exercise may go on indefinitely and therefore the appellant may not get any real relief. Full stop. The court notes that the impugned order makes the exercise time bound and requires it to be completed within 6 months. Consequently, even on this score, the court finds no grounds to interfere. The writ appeal is accordingly dismissed.
My lord, can I pray one submission, my lord? My lord, only one thing, my lord, in my written submission, written note of submission, I have given some citations and that has not been considered.
That is not a ground for interference.
My lord, that is for the fag end of my service career.
That's all right. That's all. Yes.
Item 55.
Rehabilitation assistance, my lord, 38.
All right. 308. Yeah.
Item number 56.
56, 57, 58, my lord. 8th of May, my lord, Sartapada case.
$59,
57, 58.
Yeah.
Sartapada 8th May.
57.
Item 59.
59 well 14th March, September.
14th September. All right.
Item 60.
60, your lordships, the first defect that they're showing is limitation. Actually, your lordships, there is no defect. What we do is we normally apply in the court. It was applied on 16th. By the time it was prepared, it was 22nd, 12th. So we are very much within limitations, but I think they don't reflect it when finally the order sheet is made ready. That is why this has...
What about the other petitions?
Your lordships, yes, we have to translate it into ODF, so we'll require some time.
All right. No. Have that other appeals already filed? No, not yet.
Lordship,
there's a whole batch of matters.
Lordships, yes. 60 is there and 62. 62, Mr. Mahanti is appearing. 60, I'm appearing, Lordships.
All right.
Yes, there's a very short point actually involved. The question is, in state of Odisha, we do not have anything which debars a SCBC candidate to be considered against a UR post, even if he or she avails the age relaxation. So I think the recent Supreme Court judgment also clearly stated that it's everything depends upon the particular rules, regulations of the service. So in Odisha, we don't have nothing debars us. But what they did is when they prepared the merit list, they basically, all those people who had...
Age relaxation is such a fundamental qualification.
Lordships?
Age is such a fundamental qualification.
Yes, your Lordships. But I think even in that way, even the Jitendra Singh case supports us. Where the UP...
Wasn't there a conflict of decisions and went to a larger bench? And all that?
Lordships, no, the recent judgment which came from the Gujarat, there the court said that Jitendra Singh also holds field. Everything will depend upon the particular...
I thought the key test was the essential qualification.
Lordship.
I think age is one of the essential qualifications.
Yes, but your Lordships will look at this judgment.
Anyway, you still have to cure defects?
Yes, sir.
All right. You see,
Provided it will be required to be decided for petition.
this on 25th June, 27 June, defects be cured in the meanwhile. Both this and
62 is also said.
62. All right. All right. All right.
Item 61.
The impugn order is at phase 20. Operative person at phase 30. 33, ma'am. The short grievance matters, he was appointed as against the post of TI. And he was promoted to the post of TG in the year 2006. That is the admitted fact. But the Honorable Court had directed to give him TI scale with effect from the date of his initial appointment. And there is no dispute that he was appointed against the post of TI since the date of his appointment. But that is the dispute only. He is only entitled TG scale from the date of his promotion to the post of TG that he was promoted in the year 2006. The Lordship can find it that order at page 111, madam.
So contempt is pending or?
Contempt.
Because the judgment of June 22.
That no instruction contempt, madam.
Or just a notice on both the application for stay and dismiss. It's returnable. 18 July.
Item number 63.
May I please, Lordship? This is regarding RSP, of the first disposal. The Lordship can find it page 19.
Anyway, 30th August. RS scheme, right?
RSCP, not
RSCP.
RSCP.
Ah. Who's for the other? This coming up the first time.
This come first time.
All right. Notice returnable 19 July.
But that stay of that order, because
is there a contempt?
63 and 65 both are same.
All right. Till the next day there should be a stay of impugn order. All right. 63 and 65.
Item 64.
64 Sartapada 8th May.
All right.
Item number 66.
Sartapada 8th May.
Right.
67 also Sartapada 8th May.
Item number 68.
Work charge employee 14th
14th September.
Item 69.
My lord, with your lordship's kind permission, in 69 I have appeared. In fact, there were 3 writ petitions which were heard by the Honorable Single Judge and disposed of together. And there have been 3 writ appeals before this Honorable Division Bench.
Oh.
If your lordship permits me, I will furnish the other 2 writ appeal numbers.
Okay.
And
I have the numbers. I have the numbers. My lord, that is 182. Sorry, WA 166, 182 of 2023. But
copies may be solved in all the cases so that I can assist your lordship.
Or you see, Counsel Mr. Samir Mishra was entered appearance on behalf of opposite parties.
4, probably. It will be for open number
3, 4, and 5 must be, no? Or only 4 and 5?
No, only 4.
I am appearing for that headmaster in charge, my lord. In fact, I don't have it.
Arun Kumar Chandan. I think
for respondent 4, be served copies of the writ appeal. As well as, full stop list along with WA numbers 180,
166, 182.
166 and 182 on 3rd July.
My lord, now by virtue of this order, what happened in this case? One government circular I was relying upon in 2 cases. 2 judgments passed in one date, but different orders. I have alleged that other order also for minor perusal. This one is dismissed. I was the counsel in both the cases.
It's all right. So we'll consider it all 3rd July.
So can it be earlier? Any date because he is appearing. I'll serve copies on the state for the other side.
22nd June. All right. 22nd June. All right.
I'm obliged.
Item 70.
70 25th April.
Item 71.
71 14th September.
Item 72.
72 your lordship has issued similar, but That GRS matter, your lordship had decided in WA number 401 of 2017.
All right. So notice returnable, I think like yesterday
one matter was that read appeal number 1.
Yeah, this is the concept of the appellant relies on the judgment dated Gram Rozgar Sevak. Right?
146 of 23. Yesterday, item 87 yesterday's list.
19 September 2022 in WA number 401 of 2017 bracket Gagan Bihari Patra was State of Odisha. Notice returnable. Let's start 27 June. There shall be a stay in the meanwhile.
Item 73.
May I please, Your Worship?
So how many defects? Defects you have to cure, sir. List on 5th July. Defects be cured in the meanwhile.
Item 74.
My lord, I'm appealing for OP number 3. Let him serve a copy.
In course of the day, I will submit.
Item 74.
My lord, in item 74, my lord, the office points out, my lord, that delay of 10 days.
That's all right. Tell us what the matter is.
My lord, this is a matter concerning, my lord, the appointment to the assistant professor, my lord, in the dentistry, my lord. Lordship kindly comes to page 77, that is the advertisement, Annexure 19. At page 77, Lordship will find, my lord, in pursuance of the order of the Honorable Supreme Court, passed on 10th of August 2015, in civil appeal number so-and-so, arising out of SLP number so-and-so, online applications are invited for the recruitment of the following post of assistant professors by 23rd of December 2015. Number 3 is assistant professor in dentistry. Then the method of selection, thereafter. Selection of the candidates shall be made as per the Orissa Medical Education Service Recruitment Rules 2009, taking into account the academic career and performance of the candidates in the Viva Vote test. Lordship at this point of time kindly comes to the judgment of the Honorable Supreme Court at page 87, based upon which the advertisement came. The relevant portion is at page 91.
This is a batch of matters.
Yes.
Are there no appeals by others?
Well, that of course I cannot say, my lord. Your Lordship is absolutely spot on, my lord. Though there are a batch of cases, my lord, my case has not been considered, my lord. The batch of cases deals with, my lord, the candidates who had applied as per the 2021 rules, my lord. But I come under 2009 rules, and that has not been considered as per the Supreme Court directive, my lord. That is my case.
So you were a petitioner there?
Yes. I'm one of the petitioners, my lord. My case was not considered at all.
All right. Counsel for the appellant contends that the case of the appellant was on a different footing from the other petitioners in the batch of matters which were disposed of by the common impugned order dated 23rd December 2022. Full stop. He points out that the appellant was covered by the 2009 rules, whereas the other petitioners were covered by the rules of 2021. Paragraph. You say notice returnable. 4th July.
Right.
Right.
But pray for interim order, but that this case has not come, my lord.
No. So let it be notice on that state. And then delay is condoned. Yeah.
Perfect.
There is no, it says an IA for stay.
Yes, that IA has not come, my lord.
All right.
That is 373.
373. So put down that 373.
Yes, madam.
Notice on that. Right. Release. Yes.
Item 75.
75, 8th May, my lord. 75, 76, 8th May.
All right.
Item 77.
On behalf of Mr. Pradhan Lordship, pray for adjournment, my lordship.
Why?
2 weeks time.
All right. Just say list on 6th July. Defects be cured.
All right.
Item 78.
14th of September, my lord, work charge employee.
Right.
Item number 79.
8th of May, sort for the case.
Right.
Item 80.
Item 80. I am appearing for on behalf of respondent. Single day disposal Lordship may remand, my.
All right. It is seen that the impugned order was passed on the very first day of the hearing of the writ petition without any opportunity to the appellant state to file a reply to the writ petition. On that ground, the impugned order is hereby set aside. And writ petition civil 15052 of 2022 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 7th August. This appellant state will file its parawise reply on or before 24 July, and the writ petitioners, that is, the writ petitioner will file a rejoinder, if any, thereto on or before 7th August. No further time will be granted to either party for that purpose.
Obligation.
The writ appeal is disposed of.
Item number 81.
81, 82, 83, my lord, Sartapada case, 8th of May.
All right.
Item 84.
84, job contract employment, 14th of September.
Right.
Item 85.
85, 86, 87, 88, 89, 90, 14th, and also 91, 14th September.
Right.
Item 92.
Lord, I may be permitted to withdraw this matter with the liberty to file a better application.
Liberty to
File a better application, ma'am.
This is a writ appeal, sir.
Yes, ma'am.
This first of counsel for the appellant seeks leave to withdraw the present writ appeal. Disposed of as withdrawn. Right.
Item number 93.
93, my job contract, 14th of September.
Right.
Item 94.
Item 94, I pray 1 week time because a similar case that is in WA number 731 of 2021 order was passed on 28th March. Till date, that order has not been uploaded.
Passed by us?
No, madam. Justice Talpatra, madam.
Oh.
So next week, may fix it.
All right. At the request of counsel for the appellant. List on 2nd May.
Item 95.
Well, 95, this present writ appeal has been filed challenging the order of the Honorable Single Judge, my lord, wherein the Honorable Single Judge has directed to regularize the present respondent, my lord. Here, my lord, our case is that the post against which the present respondent was appointed was created as a contractual post, my lord. You will also may kindly see.
So for item number 95 is concerned, I have prayed. Similarly, 7 to 8 cases has been already been dismissed by your lordships.
Your lordship, in another case, my lord, it is pending before the Honorable Supreme Court, my lord, and the Honorable Supreme Court, my lord,
same
as an interim measure has passed an order modifying the order of this Honorable Court, my lord. Your lordship kindly have a of the same appellant's organization, my lord. I'm just
same order was taken care by your lordship and your lordship.
To a larger bench along with some other matters, wherein the question of direction for creation of a supernumerary post in absence of a regular vacancy, whether such a direction can be given, that question, for that it has been referred to a larger bench. You also may kindly see. There are 2 writ appeals, SLPs listed on the same day. The first writ appeal, my lord, you also may kindly see SLP number 24226 of 2022. Therein,
this was also brought to your lordship's notice. Your lordship said that raise this issue before the Honorable Supreme Court and dismiss the writ appeal filed by the state millets. I have the copy of the order millets, but inadvertently I had kept that in another copy. Your lordship may give me 1%, I'll forward the copy. I have the writ number also.
There are 2 batches going on.
my lords,
There are 2 batches of matters.
my lords.
So one batch, the SLP has been dismissed. That's
My lords. Here, my lord, here
this comes under the first batch.
Pardon, my lords.
No. There appears to be 2 batches of matters.
My lords.
One where the matters are being referred to a larger bench.
My lords.
But another where following the SLP order, other SLPs are being dismissed.
My lords.
So this falls in the first category.
It falls in the first category, my lord, because there is a post here. There is no.
The appellant refers to an order dated 10th February 2023, passed by the learned single Supreme Court of India in SLP Civil 24226 of 2022, directed against a judgment dated 25th August 2022, passed with this court. in WA 363 of 2021.
Here, my lord, the petition is containing again the sanctioned
It
post.
appears that by the said order, the SLP was tagged with civil appeal number 1878 of 2016, bracket, Oil and Natural Gas Corporation versus Krishan Gopal, bracket, on the question whether the power to create permanent or sanctioned posts lies in the judicial domain. The present counsel for the respondent wants to produce orders passed by this court in similar interpleads. Full stop. We'll give a longish date, then we'll know the fate of the list on 4th September.
I have the copy with me. I have the order passed by your lordship right now.
It's okay.
Your lordship,
Anyway, the matter is now in the Supreme Court.
My lord, I have prayed for an interim order, my lord.
My lord, here,
My lord, I have prayed for an interim order.
my lord, the petitioner is here.
Notice
The,
on that stay also.
my lord, here the respondent is continuing against the back end post. My lord.
All right.
My lord, the status quo with respect to the continuance of the
Same order will pass since the Supreme Court has permitted.
Yes, yes.
The respondents in the above SLP to continue in service. The same interim order is passed in the present written.
My lord, my lord.
All right.
Item number 96.
96, this matter is stood adjourned to my lord 1st of May. Actually, there is an urgency regarding certain wanton violation of the state in compliance with the direction of this honorable court.
Yes, yes.
Actually,
Sure.
this matter be taken up at 2 o'clock.
Not be possible to take
So
it.
let it be called up at the end of the list. Learned amicus curiae is on his legs.
I have a matter at 2 o'clock, my lord, before another.
It will be called up at the end of the list.
My lord, end of the report.
Item number 98.
Item 98, if your lordship sees, my lord, the noting, my lord, the last portion of the noting, item 98, the first item, my lord, a letter has been received from Special Secretary PH to government regarding giving one-time direct financial assistance at Flag T. That was pursuant to a lordship's direction, my lord.
Yes.
That is letter dated 4/3/2023, my lord.
Right.
The first paragraph, lordship may kindly see. On the lordship's last occasion, directed to take instruction whether the patient suffering from such disease be provided with any financial assistance directly, which would be independent of any schemes for the treatment.
Right.
That was basing upon a suggestion that Bihar government is providing 6 lakhs rupees.
Correct.
Lordship may kindly see para 2, we have said that 5 lakhs per annum that's eligibility for a family and additional 5 lakhs for women members.
Right.
That part, para 3, lordship may kindly see. It's mentioned that the proposal for giving one-time direct financial assistance independent of any scheme to the patients suffering from this DMD is under active consideration of the government and expeditious steps. Lordship, today in the morning we have taken instruction. 10 days, 12, 14 days time, lordship may give, at least something can be worked out, my lord.
Council of the State seeks a short adjournment on the issue whether the one-time assistance to the parents of the patients suffering from DND can be enhanced on par with the relief provided by the government of Bihar. List on.
Lordship, may I submit something? Lordship, here in Amri Hospital is the hospital where one of the kids was admitted recently, Lordship. In my IA, one of the children who was admitted in Amri, which is an empaneled BSKY hospital, Lordship, despite being empaneled, they provided no financial assistance.
File an affidavit or something, sir.
Yes.
Then we can ask them to reply.
Yes, ma'am. Unfortunately, that child has passed away.
So you file whatever, you filed an affidavit, then we'll ask them to reply.
I'll do.
18th May. My lord is speaking 18th May.
18th May.
Great.
All the 3 cases may be.
Yes, yes. 2 cases.
Item 99.
May you please, your lordship, my lord, kindly taken up for next week.
For what, sir? What's the matter about?
My lord, matter is, my lord,
I am challenging the order of Honorable Single Judge, my lord. The fact of case is that the respondent filed a writ application against the order of the Commissioner Consolidation, my lord, settlement under section 15B. That the respondent filed an application under section 15B of OSS Act before the Commissioner Consolidation and Settlement, my lord, on the ground that the suit plot has been, sorry, my lord, the father of the respondent purchased the suit land from the father of the appellant, my lord. The caste of the appellant is Kondora. They are the scheduled caste person, my lord. So during the whole settlement operation.
Anyway, this is coming up after notice. Who's appearing for the other side? There's some Rupesh Kumar.
My lord, I'm Akash Acharya. Ma'am, I'm appearing for opposite party number 1, opposite party number 1, 2, and 4, and 5 and 6.
Only 3, somebody else is appearing.
The 3 is
2 and 3.
Dead, my lord. 3 is dead, my lord.
3 is dead.
My lord, as per the noting, my lord.
Then you have to take steps.
My lord.
Respondent number 3 is stated to have expired. Steps be taken by the appellant to bring her legal representatives on record. List on. No, but he's appearing. You're there for 4, sir.
My lord, 5 and 6.
Okay, he appears for 1, 5, and 6.
1, 2, 5, and 6.
1, 2, 5, and 6. You say notice to respondent 4 has been returned unserved. Absent. With the remarks absent. Absent, all right. Not that the address is incorrect. Address is wrong.
Are brothers, my lord, if they receive that notice.
4 is a brother of 5 and 6, he says. Anyway, you take instructions.
My lord.
11 July.
Oblige,
my lord. Oblige, lord.
Item number 100.
My impugn order is at page 13.
You are appearing for TPC ODL.
My friend is appearing.
Achha.
That this is a matter where the direction has been given to give promotion during pendency of that admitted fact, that is a departmental proceeding as well as that vigilance case. And this has been disposed on the very first day. And in the meantime, in the departmental proceeding, he has been also imposed with the punishment.
It's coming up after notice for the other side.
His name appears.
Mr. B. Mansingh. One, Mr. B. Mansingh has entered appearance on behalf of advocate, has entered appearance on behalf of respondent 1. Today, however, he is not appearing. The registry will telephonically inform him to remain present on the next date. Interim order to continue. List on 19 July.
Before that, some similar matters are coming on 11th May.
That you point out and we can. All right.
Pastor. Supplementary list, pastor matter, item number 35.
May I please ask?
Yes.
This case, my lord, all these petitioners were before the Honorable Single Judge in WPC 2948 of 2021, challenging the advertisement for recruitment of assistant professor stage 1. 2 other petitions also filed by 2 other persons, challenging the selection procedure, not the advertisement. The provision of the advertisement, they were not challenged, but all these 3 cases were disposed of by a common order and judgment. And so far my case was concerned, it was stated that once you have kindly, my lord, gone to page 94, the synopsis of that order. So far this case is 95, relevant is 95. Only on the premises this was dismissed that once you have participated in the process of selection,
You cannot question.
You cannot question. But so far these petitioners are concerned, they have not participated.
I see.
They have kindly have a glance
All
to
right.
the
Constable, the appellant states that
writ
the appeal
petition.
order proceeds on the basis that once the petitioners had participated in the selection process, they cannot question the terms and conditions to be fulfilled. It is submitted that the present appellants did not participate in the selection process and therefore their case stands on a different footing. See, notice returnable. 24 July.
Item number 96.
If your lordship may kindly have a look at lordship's order number 16 dated 2012 to 2022, lordship.
Yes.
Certain directions, specific directions had been passed by your lordships. Copy it here. For compliance, filing a convenience note for your lordship to see as regards to the utter violation that have been made. This is evident from the affidavit that has been shown by Mr. Mohammad Kamrullah, apparently signed on the 1st of March 2023.
Which para of the order?
Lordship, the first 4 paragraphs of your lordship's order, specific directions had been granted. More importantly, lordship may kindly come to this paragraph number 2, lordship. As regards the videography of the social audit meetings and uploading of it in the website of Odisha State Food Commission OSFC, a copy of the instruction issued on 20th of September 2021 and 15th of December 2021 has been enclosed. The separate affidavits filed by the Additional Secretary to the Government in Women and Child Development Department and the Joint Secretary to Government in PR and DW Department also proceeds on the basis as of social audit is to be conducted only of the FPVS. They do not give any particulars of the actual audit of implementation of various schemes referred to by this court on its order dated 23rd of August 2021. But much more important is the 3rd paragraph. At this stage, the attention of the court is drawn by Mr. Gautam Mishra, learned amicus curiae, to the specific directions issued on 23rd of August 2021, where court had required the government to place before it by way of an affidavit details of the social audit conducted for implementation of all schemes, not limited to TDPs. The videography of such meetings held as part of the social audit was directed to be uploaded in the website of OSFC. The court specified in the order that the social audit should not be confined to the entitlements under the TPDS, but include other schemes, including midday meal, integrated child development scheme, maternity benefit scheme.
All right. We'll just say a brief note of submissions has been submitted today by the amicus curiae, pointing out that the state of Orissa has not complied with the specific directions issued by this court on 2nd February 2021, 24th March 2021, 23rd August 2021, and 20th December 2022. The precise non-compliance have been set out in the note, copy of which has been handed over to Mr. B.P. Tripathi, Learned Counsel Appears for the state. He undertakes to obtain specific instructions on each of the points made in the said note. This is IA number. Today is what? Listed for IA number something. Or just because of mentioning. All right. Don't put IA. When is the next date here fixed?
It was supposed to come up on the 1st of May. Amicus curiae.
We'll get them to respond to this by 1st May. An affidavit will be filed by the Joint Secretary to the Government, Department of, which would be the department?
4th department, my lord, which had filed the
special, should be filed by the Special Secretary to the Government, Food and Supplies and Consumer Welfare Department, Odisha. At least 2 days prior to the next date, with an advance copy to the learned amicus.
I'm sorry, I couldn't count, my lords.
No problem.
May I just show that affidavit? What has happened, my lords?
No, they've not done the social audit of all the schemes you say.
That is one. My lords, may kindly see one document from that affidavit dated 1/3/2023. Sworn to Mr. Mohammad Kamrul Haq. Now, if my lord would see, what is troubling me, my lords, on page number 11, This is a minute dated 16/2/2023. And in that, if my lord may see, page 11, proposal to conduct social audit for any scheme of the government, they say. Then on the next page, my lord may kindly see, page 12. I hope my lord finds it. SAU, Odisha has a pool of trained manpower. This is additional affidavit dated 1/3/2023, sworn to Mr. Kamrul Haq. That my lord would see internal page 12 of that affidavit.
Yes.
So SAO, Odisha has a pool of trained manpower to conduct social audit of any scheme. Then my lord may kindly see, on request of Special Secretary F so and so, it was decided that OSAT may share some videography of social audit process, Gram Sabha 2020-21 under so and so from the following districts. Then my lord may kindly see, S and ME department will submit confirmation to social audit of PM Poshan scheme by 2nd week of February. Now this is signed in on 16/2/2023. They give directions to comply with this by the 2nd week. Then OSAT, next direction, OSAT shall submit balanced social audit report of 10.
Obviously, this has been signed much later.
So my lords, even if this is signed on 16th, they are giving about 7-8 days to complete social audit of all these.
Impractical. Let him respond to this.
My lords. In fact, they have not followed any of the directions.
That's what I've said that. All right. List on first, may the date all fixed. All right.
We are grateful.
This list is over. All right.
We are really grateful.
All right.
Supplemental list, fresh admission item number 1, CRLNC 583 of 2019.
May I please, Your Lordship. Petitioner failings to this one court for quashing of a criminal proceeding in view of the compromise between the party, my lord. The informant as well as the victim already enter appearance.
All right. The affidavits of OP numbers 2 and 3 confirming that they have settled their disputes with the petitioners have been filed. Counsel for opposite parties 2 and 3 also confirms this. That we have the matter take from the prayer clause and all proceedings consequent thereto. I hereby quash.
Item number 2.
Nana, please.
Item number 3.
This application filed to questioning the FIR matter on the basis of the complaint filed by the opposite party number 2, that magistrate has sent the message on the 156.3 and the FIR was lodged. But no inquiry has been conducted, no report has been submitted. 6 years, 8 months has been passed from the date of filing of the application.
Because of this, what happened?
The allegation is that the land of the opposite party number 2 has been mortgaged from a tractor loan without his knowledge. That is the allegation.
Permitting the petition to raise all please at the appropriate stage, petition is disposed of. All right.
Item number 4.
None appears.
My lord, and item 4. May I please, Your Lordship?
Alleged
offence under section 366 of the IPC, my lord. I'm highly criminal miscase for quashing of the FIR, my lord. Matter is settled, my lord.
All right. The affidavits of the opposite party informant.
Flag C, my lord.
Yeah, has been bracket flag C has been produced.
I'm
Counsel appearing for opposite party number 2 also has no objection to the
2 and 3 both.
Yeah, 2, 3, and 4 also says he has no objection to the quashing of the case. That view of the matter takes from the prayer clause and all proceedings consequent that hereby quashed.
Item number 5.
May I please, my lords. Petitioner challenges the order of cognizance, my lords, at annexure 3, my lords, page 24 to 31. with Lordship's permission, may I draw Lordship's kind attention to Annexure 4. MOU was filed between the parties, that is the complainant OP number 2 and the present petitioners, my lords, pursuant to which all the 1cc cases that is of NI Act were withdrawn before the learned SDJM, my lords. And in the said MOU at page 34, in the recitals of the MOU at paragraph G, my lords, it is stated that the further it has been mutually agreed between both the parties that neither of them shall file any case, bracketed criminal, civil, etc., against each other arising out of their earlier dispute in future, and both parties will end all the litigations which are pending before any court or forum, etc., my lords. It was duly signed, my lords. Inadvertently, on the last occasion, my lords, on the date of admission, notice was not been issued to the opposite party number 2. My instruction as on date, it suggests, my lords, the matter has been settled and he is willing to appear. Lordship may issue notice. I'll
Counsel, the petition refers to Annexure 4 and states it is an MOU recording the settlement of the disputes between the parties. Notice returnable before the roster bench on 16th May.
Much okay.
Except for the state, notice to the remaining opposite parties by registered speed post tracking report will be placed on record. Right.
Much okay.
Item number 6.
May I please, Lord? My lord, the petitioner is the wife, whereas the opposite party is the husband. Now, my lord, the order passed by the revisional court in a proceeding under section 97 of CRPC, reversing the order passed by the Lord Magistrate, issuing the search warrant in respect of the minor son of the petitioner, which is taken away by the husband. The Annexure 6 is the impugned order, your lordship. No notice has been issued. The lordship may.
This is already, the search warrant has not been executed still.
No, my lord.
How come you're evading? You're not a.
No, that order has been set aside by the learned revisional court. That is Annexure 6, page 42. That order is under challenge.
Must be so many other proceedings, sir. There must be other proceedings between the two of you. Aren't there other proceedings between the husband and wife?
Yes, no, husband and wife. But by using the police force, my lord, he has taken the minor son. The other.
What are the other proceedings pending?
No other proceeding is pending, my lord.
How can it be, sir? No other proceeding is pending.
No, to my instruction at that time it was not pending. Of course, I don't know what is the subsequent development.
You better find out, sir. Counsel for the petitioner seeks time to find out about subsequent developments. For the roster bench on 3rd May.
Item number 7.
Item number 7, my lord, no instruction.
No instructions dismissed.
Item 8.
May I please, lordship? Item 8 may be taken up one chapter, my lord. Because the Mr. Manoj Kumar Malik is out of station, my lord.
That's not a ground, sir. What's the matter about? Permitting the petitioner to raise all pleas at the appropriate stage.
Item 9.
None appears dismissed.
Item number 10.
None appears dismissed.
10 matter not pressed, your lordship.
10 not pressed dismissed.
Item 11.
None appears dismissed.
Item 12.
I am on behalf of Mr. Kuras Prasad Das. Kuras Prasad Das, ill, my lord, kindly taken up next week.
What's the matter about, sir? Let's see. Permitting the petitioner to raise all pleas at the appropriate stage. Just note down his presence. Please give your presence.
Item number 13.
None appears dismissed.
Item 14.
Same order.
Item number 15.
15, my lord, not pressed.
Not pressed dismissed.
Public.
Item number 16.
None appears dismissed.
Item number 17.
Not permitted to withdraw, my lord.
Dismisses withdraw.
Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item number 20.
Say what?
20 and for opposite.
Not rest dismissed. All right.
Opposite party.
Okay, opposite party.
Yes, ma'am.
All right. None appears with the petitioner dismissed. Right.
Item 21.
Item 21, my lord, no instructions.
No instructions dismissed.
Obliged.
Item 22.
My lord, permitted to withdraw.
Dismissed is withdrawn.
Item 23.
May please, Your Lordship. Your Lordship, liberty may be granted to raise all contentions.
All right. Forward to the petitioner.
Your Lordship, one more thing, Your Lordship. The petitioner number 1, meanwhile, the petitioner number 1 and petitioner number 3 have died, Your Lordship.
That's all right. You point that out. All right.
Item number 24.
None appears dismissed.
Item 25.
My lord, may I please your lordship, my lord. Not the disquieting case picture is, my lord. The learned trial court has committed error apparent with the face of record. May I invite lordship's kind attention, page 7, my lord. This is the impugned order. The learned trial court has, it is a matter relating to addition of charge, addition of offense for pertaining to 379, 506 and other, my lord. 80,000 some odd has been taken away, snatched away, theft committed by the opposite part number 1. We made an application of 216 million before the learned trial court. The learned trial court, even the material, the telltale material is available, was very much on record. The learned trial court has not taken a framing charge.
There's one more stage for that, sir, after investigation.
My lord,
there will be one more stage for that for you to point out.
216 million, my humble submission, 216, there's no stage, my lord. 216.
No, the stage of charge, if the court finds that evidence has been created.
Charge has been framed, Lord. That's what charge has been framed.
But there's one more stage, sir, after charge being framed.
Your lordship, charge sheet has already been framed, my lord. Your lordship may say, my lord.
Charge framed is different from charge sheet being filed.
Yes, charge sheet is filed. Charge sheet is filed by the police.
Charge has been framed after that?
Yes, charge has been framed.
Where's the order framing charge?
Lord, order framing charge I have not annexed. I have made the application.
Then you challenge that.
Lord, then your lordship may say, Lord, we make a prayer.
If you have subsequent developments, counsel for the petitioner seeks leave to withdraw the present petition.
Then to move the trial court
to seek other appropriate remedies against the order framing charge.
Yes, then to re-edit the matter.
Whatever. This post is withdrawn with liberty straight form. All right.
Item number 26.
May I please, your lordship. Lordship, charge has been framed under section 497 IPC, though it was declared unconstitutional in 2018. In 2019, charge has been framed. And the petitioner was caught in a compromising position with her paramour by her husband.
All right. We said it is pointed out that despite judgment of the Supreme Court in Joseph Shine versus Union of India, what's the citation, sir? 2018?
Citation.
Charges been framed by the SJMFC, Bhavani Patna, on 5th December 2018 in CT case number 339 of 2017. It's a notice returnable. You are for the state?
Yes, madam.
What do you say?
Well, it was declared unconstitutional after the order was passed.
No. The order was passed in 2019. It was unconstitutional in 2018.
Give us the citation, sir. What is the date of the judgment?
The judgment date is 27/9/2018.
Despite the judgment dated 27/9/2018, orders framing charge has been passed on 5th December 2018. So this has to get passed in that view of the matter. It's a notice, he accepts notice. Since the legal position is absolutely clear. It is clear. It is obvious that the order framing charge is unsustainable in law. Stop. It is accordingly hereby set aside. In other words, the petitioner will stand discharged in CT case number 339 of 2017, pending the court of SJMFC, Bhavani Patna. A copy of this order be sent to the said court forthwith.
Item 27,
None appears dismissed.
28,
Same order.
Not present.
Not pressed. 28.
item 29,
None appears.
item number 30,
None appears.
31,
Same order.
item number 32,
Same order.
item 33,
Same order.
item number 34,
Same order.
item 35,
Same order.
item number 36,
Same order.
37,
Same order.
item number 38,
Same order.
39,
Same order.
item number 40,
And 40 on behalf of Mr. Samantara, liberty be granted to
Yeah.
raise all
Permitting
those points.
petitioner to raise all, please. All right.
item 41,
None appears dismissed.
42,
Same order.
item number 43,
Same order.
item 44,
Same order.
item number 45,
45 on behalf of Mr. Rakesh, I have kindly, no instruction, my lord.
No instructions dismissed.
item 46,
None appears dismissed.
47,
Same order.
item number 48,
My lord, permitted to withdraw.
Dismisses withdraw.
item 49,
Lordship, item 49, liberty may be granted to raise all the pleas.
All right. Permitting the petition.
item number 50,
None appears dismissed.
51,
Same order.
item 52,
Same order.
53,
Same order.
54,
Same.
item 55,
55, my lord. This case, my lord, the implied annexure 2, my lord, limitation petition has been rejected on the ground that the advocate was absent, not pressed. Only, your lordship, I am permitted to move in the lower court.
All right. Permitting the petitioner to raise all, please. Be a proper stage.
item number 56,
None appears dismissed.
item number 57,
Same order.
58,
Same order.
item number 59,
59 may place it. Then in that case, means the present person challenging the illegal and arbitrary order of NBW dated 25 to 19 minutes issued by the law and court below. The present person has already in bail.
It's all infructuous, sir. Due to passage of time.
Permitted to withdraw.
Dismisses withdraw.
Obliged.
item number 60,
May please, your lordship. This matter has been amicably settled between the parties. 354 allegation only. The affidavit to that effect has been submitted by the informer.
Where is the affidavit? The affidavit of the informant stating that the matter has been settled is taken on, has been tendered, is taken on record. So 2020 affidavit.
Yes, your lordship. It was not listed. First time it was listed on 2/9/2/12.
Where's the lawyer? Where's this SR Biswal? Where is he? Some lawyers, Vakalat Nama is also here, sir. You better file it in court. Just give it back. Counsel to the petitioner states that he will be filing the affidavit of the informant or about settling the disputes within 1 week. This for the roster bench on 8 May.
item 61,
None appears dismissed.
62,
Same order.
63,
Influctuous.
Dismissed as infructuous.
item number 64,
None appears dismissed.
item 65,
Same order.
66,
Same order.
item number 67,
67, my lord, no instruction with
No
liberty
instruction dismissed.
fresh cause of.
No. No instructions dismissed.
Item number 68,
None appears dismissed.
69,
69 on behalf of Mr. Samantha Liberty be given to raise all.
Permitting the petitioner.
item number 70,
None appears dismissed.
71,
Same order.
item number 72,
Same order.
My lord, I am appearing for the petitioner here, my lord.
Yes.
This has been compromised, my lord. On the numerous occasions, both the parties were present before this court, my lord, but some of the matter could not be taken up because of paucity of time. Now, directly thereafter, after 2020, it is listed for the first time, my lord. There is a stay order operating, my lord. In the meantime, mutual divorce has already been allowed.
All right.
It is a compromise matter, my lord.
Annex 2 is the copy of the. No, but where's the order of granting divorce? That's not placed on record, sir.
My lord, that I'll file. It is
Counsel, the
only
petitioner
listed.
seeks time to place on record the copy of the divorce decree under section 13 capital B of the Hindu Marriage Act 1955. This is for the roster bench on 3rd July.
Obliged. Interim order to continue, my lord, because there is an interim order.
Nothing will happen, sir. Nothing.
item number 73,
I am for the opposite.
None appears the petitioner dismissed.
item number 74,
Lordship, item 74, liberty may be granted to raise all the.
All right. Permitting the petition.
I'm for the implement, my lord, in 74.
All right. All right.
item 75,
Lords, 75, may I please, can we have it after lunch because it will take some time. A non-signatory on a promissory note has been made and accused under 138 of the Negotiable Instrument Act. So I have a note
Who's
prepared.
the other side?
Other side is there.
Too.
Yes.
See here, he's a party to the power of attorney. Property belongs to the accused person. They have agreement. And by virtue of power of attorney, he has been appointed. One of the accused has been appointed as to deal with it.
What is the amount involved?
Amount 50 lakhs.
Oh. You place it before the roster bench. You say place before the roster bench for hearing on 11 July. Interim order to continue.
Grateful.
76,
11th of July.
None appears dismissed.
77,
Same order.
item number 78,
Same order.
79,
Same order.
item number 80,
Same order.